This is Barry Zalma speaking for Claims School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why a liability insurer has the sole right to settle suits against the insured, and why an insurer's report to an insurance support organization is privileged. And as we go through the facts, we will see that the suit brought against an insurer for settling a lawsuit against its insured is an act designed to deprive the insurer of the benefits of the contract of insurance. In essence, the definition of the tort of bad faith. Allstate Northbrook Indemnity Company moved for judgment on the pleadings brought by Plaintiff Zhiwei Chen, opposed, and Allstate filed a reply. After considering the moving, opposing, and reply papers and the arguments therein, the court in Zhiwei Chen v. Allstate Northbrook Indemnity Company, the United States District Court for the Central District of California on October 2, 2024, resolved the motion without oral argument. The facts stated that on January 16, 2023, plaintiff was delivering food for Uber when he was involved in an automobile accident. At the time of the accident, Allstate insured plaintiff's car under an automobile insurance policy, and the policy provided that Allstate may settle any claim or suit if Allstate believes it is proper. After the accident, a claim was made to Allstate against plaintiff, and Allstate settled that claim. Plaintiff alleged that Allstate reported the claim to LexisNexis and that Allstate's reporting of the claim and accident caused an increase in his premiums. Plaintiff sued Allstate in Los Angeles Superior Court, alleging claims for breach of contract, breach of the implied duty of good faith and fair dealing, insurance fraud, defamation, and intentional infliction of emotional distress. Allstate removed the action to the United States District Court and made a motion for judgment on the pleading. Allstate argued that because the policy gives Allstate the discretion to settle any claim that it believes is proper, plaintiff cannot succeed on any of his claims. Federal Rule of Civil Procedure 12C governs motions for judgment on the pleadings as with motions brought pursuant to Rule 12b-6. In addition to assuming the truth of the facts pled, the court must construe all reasonable inferences drawn from those facts in the non-moving party's favor. The policy gave Allstate the absolute discretion to settle any claim, and in this case it is undisputed that the policy provided Allstate with the right to settle. As a result, because Allstate had the contractual right to settle any claim, it cannot be liable under any cause of action alleged by the plaintiff for settling a claim, and the insured's policy gave the insurer the right to settlement as it deemed expedient, and since this type of clause is not unusual in liability insurance policies and is appropriate to the benefit of both the insurer and the insured, as a result, an insurer normally cannot be liable to the insured if the insurer does no more than settle a claim or suit within the policy's limits. Because Allstate had that right, it believes it was proper, plaintiff cannot maintain a cause of action against it. Then he sued Allstate for reporting the claim to LexisNexis, and that report caused him to pay extra premium, and a plaintiff cannot maintain a cause of action against Allstate based on Allstate's reporting that plaintiff was involved in an accident and that it settled the claim against him, because Allstate's reporting of plaintiff's claim is privileged. Specifically, California Insurance Code Section 791.13 allows an insurer to report personal and privileged information to an insurance support organization when necessary to perform its function in connection with an insurance transaction involving an individual. Plaintiff bases his claim on the fact that Allstate reported information about plaintiff's accident to LexisNexis. Plaintiff also alleges that LexisNexis disseminated that information to other insurers who used the information released by Allstate to judge plaintiff unfavorably, which led to plaintiff paying more for insurance than before. The USDC concluded that Allstate's alleged reporting of plaintiff's claim is privileged and as a result cannot support a cause of action, and all of plaintiff's claims alleged in the complaint, including claims for breach of contract, breach of the implied duty of good faith and fair dealing, insurance fraud, defamation, and intentional infliction of emotional distress, were dismissed without leave to amend. In my opinion, the USDC did away with this odd lawsuit without a need for oral argument, because if the plaintiff tried to renew his policy with Allstate, Allstate knew about the accident and would consider that accident in reaching a premium. And if he tried to get insurance from another insurance company, he would invariably be asked to fill out an application which would ask about his prior accidents. So if he was honest, he would have told any new insurer about the accident, and that would have caused his premiums to go up. Settling claims against the plaintiff was why the plaintiff bought insurance from Allstate. He got what he paid for when they settled the claim, and they reported the claim to an insurance support organization who was in business of providing that information to insurers. The plaintiff hoped, it seems, by alleging bad faith, he could bludgeon Allstate into paying him off. His attempt failed. In fact, the plaintiff's actions were designed to deprive the insurer Allstate of the benefits of the contract, fitting the definition of the tort of bad faith. And I'm sure Allstate is now thrilled that he is no longer insured with them. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you will have access to the more than 4,900 blog postings. You can also subscribe to these videos. They're also free. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And please tell your friends and colleagues about this blog so that they too can subscribe to the blog and or the videos. Thank you for your attention. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you again.